9-17340, Gail Corder Fisher versus Cliff Fisher. Counsel, make your appearances.
Alan Lowenson for the defendants, Ted Uzelak and Larry Teal, movements on 2 of the motions today.
Seymour Roberts Jr. for Clifford Fisher and Company, the intervener plaintiff, and Clifford Fisher, one of the defendants.
Robert Epstein for Clifford Fisher in connection with the joint motion to compel the resumption of Gail Corder Fisher's deposition.
And Don Godwin, Your Honor, would Morgan Scott and would Kristen Burns here for Gail Fisher.
Nancy, there's something wrong with your sound, or someone's sound.
I'm not hearing anything.
Do you hear that?
That was going on this morning when we got here.
Okay. All right. Never mind. We have sound. The courthouse has sound problems. It's not the Zoom call. So I've had a chance to look at this motion to compel the deposition of Gail Fisher. And so I had a few questions of everyone. So as I understand it, one of the issues is whether or not she'll be able to do closed captioning for her next deposition. And I guess I just didn't see a problem with that, but I'd be glad to hear, or any authority that that's not allowed. But who is opposing her being able to do that?
All the defendants, Your Honor, so I can speak to that for the court.
Okay.
First of all, I think there is a burden of proof question here. And that is, who bears the burden of proof on this motion?
Why is there a burden of proof? What are the rules that say you can't do closed captioning?
Well, I guess I would say back to the court, where does it say that you can? And the issue is, should you be able to? I have never had a witness in 42 years do that or request to do that. They have cited no authority that they can, but more importantly,
how is it any different than having a translator? I guess this person doesn't be able to hear. She needs to be able to close caption. She has a sworn, or she has a doctor's note or a doctor's report from an audiologist. Why not allow it? I guess. Okay. Well,
I think you've asked several questions in one. If I could address them.
Right.
The first question you've asked, the first assumption by the question is that she has established that she needs it. And with all due respect, I don't think she has. If I may speak to that first. The doctor who examined her, according to this letter from the audiologist, found nothing remarkable. The audiologist found in a letter, without giving us test results, that she could hear fine in her right ear. In fact, it was perfect in her right ear. We then got the test results and we showed them to a board certified medical doctor who examined them, who concluded she had, according to the test, 100% perfect in her right ear, and that typically someone with perfect in their right ear can hear just fine as long as there's not a lot of background noise. And then if you augment it, if needed, additionally with headphones, if you want it, then he concluded this person does not have a hearing disability that would require her to have the special circumstance of having closed caption. So that's the first thing. I don't think she's established that she has a hearing issue. And that is different from an interpreter, because in a clear example of interpreter, if I don't speak the language, by definition, I cannot understand the question. But I think it is a burden of proof question because, Your Honor, no one else has the luxury of having the questions there. And I'm going to get to the court's second question in a minute, but no one else has the luxury. And to my knowledge, I've never had the experience of someone saying they wanted the luxury of being able to have the questions projected onto them. So she doesn't have the disability that would justify it. And in fact, as we set out on our motion, very suspicious circumstances to suggest that she does, because at the deposition, she was asked, is there any reason you can't understand? She said no. In fact, she said, absolutely not. And then said, because it's Zoom, I say this to everyone, if you can't hear me, let me know. And she said, I absolutely will. One time in 305 pages, she said, I can't hear you because your hand is in front of your mouth. I repeated the question and then she answered it. It was only after she changed her deposition a staggering 172 times, also unprecedented in my 42-year career, that she claimed that that was the reason she couldn't understand. First of all, that's not believable because in fact, we later learned that, as you know, unbeknownst to us, it was going on all morning. It wasn't told to us and into the afternoon. And Mr. Godwin later admits in a letter that she was using the transcript to be able to quote, hear and understand. And yet she still changed 42 answers from that portion.
I agree with you. That is unusual. And I see that as a separate issue.
Well, the reason I'm mentioning it, Your Honor, is this. If her position was I had to change my answers because I couldn't hear, which is her position, it is belied by the fact that when she had the transcript, she still changed 41 of her answers. So it can't be she didn't understand them and didn't hear them, and that's why she changed them, because she, unbeknownst to us at the time, had the transcript when she had the ability to read them. And it was only after she changed them 172 times that she said, oh, I've got this hearing problem and I can't hear. Now let me directly address your other question. Why is that unfair? It's unfair for three reasons. One, the purpose of a deposition, as opposed to an interrogatory, is to obtain spontaneous sworn answers from a witness, the same way it is in court. In court, witnesses don't have the transcript projected above them. Why is that an advantage? Because it allows a witness, and we know this witness will parse through things by virtue of the fact what she's done since her deposition, to sit there and parse through the words and see if she can find a way to avoid telling the truth, which is what happened in her changed answers here. So it is an advantage. It's an unfair advantage, and it turns a deposition into an interrogatory. Otherwise, the rules would provide for closed captioning. And when Your Honor says to me, where is it in the rules? My response is, it's not that someone can't use it. It's not in the rules that anyone can use it. And again, I've never seen it in 42 years. That's number one. Number two, it's going to prolong the depositions because now we have to wait for the witness to hear the question, then sit and read the question, parse through it, figure out how do I answer it, then wait for the answer. That inevitably.
Can't we deal with that issue though with just extending the length of the deposition? I mean, it's exactly what you have when you have a translator. I mean, all of the issues that you've raised are exactly the same issues that happen with their translator. Well, and I guess under that reasoning, then you shouldn't have a translator because they can't. Even because how many times have you, and I know you've seen this in your 42 years and I've seen it in my 28 years or whatever it is at this point, many times where people who could speak some English, but preferred Spanish or another language, used the translator. And so they were able to kind of hear it twice. To me, this is kind of the same thing. It's somebody who understands fairly well, but needs additional assistance. I don't see a problem with it. I do see a problem with trying to use that as a basis. Like, I would not want it to be said to the jury that the reason she changed her answers 142 times was because of the translation. Because of the lack of, I guess, closed captioning. I agree with that in that you shouldn't be able to say, look, the reason my answers were wrong is because the translation was wrong, as long as you have a certified translator. And so,
well, can I don't know if the court's mind is already made up, but
the court's mind is already made up on that point, on the point of what to do with the 142 changes and all that kind of stuff. I would say we need to figure that out because I don't think it's fair to y'all to say, look, the reason to be able to tell the jury the reason that we made all of these changes is we couldn't understand it. I don't think that's fair. And so we need to kind of figure out that particular issue. But I don't see a problem with closed captioning. Right. And go ahead.
No, I mean, I have additional things to say, but if the court's made up mind, I don't want to waste everybody's time. So, I mean,
appreciate that.
So can I speak to then the errata changes and the
absolutely
how to handle that? So 172 changes initially. We requested the right to resume or depot. Counsel said, I understand I can't argue you can't redepose her, but as a condition for my agreement, you've got to agree, his initial position was a set limit of 3 hours. And you have to agree that you can't exercise your right under the Texas rules to come back to the court for more time if you can justify it. We don't think there ought to be a time limit for the following reasons. We can't predict in advance how long it's going to take, and let me give you a few examples. She changed answers from, I don't know if I have damages, to a number of answers stating she has damages, but not stating what they are. So we have no idea when she's pressed what she's going to say, how long it's going to take for her to do it. Second of all.
So first, let me say, I am never going to allow an unlimited deposition. So you need to come up with, I agree.
I
you
have
should
a
give more
proposal.
time.
I
Okay.
have a proposal.
Okay.
Last week, Mr. Godwin said, okay, I'll agree to 6 hours, but you have to agree that no matter what happens to the deposition, you can't come back to court and ask for more time. That sounds absurd to me. We are
No, I
willing
agree with
to
you.
agree to. So here's the issues. One, we're willing to agree a 6-hour limit as long as it's clear we've got a right to come back and they've got a right to oppose it. That's issue one. The second,
Mr. Godwin, that seems fair.
Judge, I was the one that made the offer, and I'm a little surprised that Alan is here talking about what we discussed in terms of trying to resolve issues. My understanding was we were having issues or settlement issues over an issue that was going to be presented. And I said, you know, Alan, I can understand you wanted to redepose her, and I'm willing to give you up to 3 hours. And he came back and said, well, we could work on the time, but I don't want to have closed captioning. And I said, well, you know, we need to have that for the reason the doctor said she's got a problem. We're past that issue. As we worked on through it, Judge, I called Mr. Lowenson back last week and I said, Alan, I said, I'm trying to work through this with you so we don't waste the judge's time on a matter as simple as taking a deposition. And let me say this, Judge, I've taken hundreds and maybe thousands of depositions over my long career. And I will tell you that I have many, many times been in depositions, which were live depositions with lawyers in the room, when the lawyers and the witness would have a real-time video monitor provided by the court reporter to be able so that you could see the questions, particularly with lawyers that ask unusually long questions, as Alan does. None of them are simple questions. They're duplicitous, they're multifarious. Several of his questions, Judge, lasted as long as 8 lines. Nobody could follow that. And I said, Alan, in order to try to resolve that, why don't we take and do 6 hours? She's been deposed already twice for 6 hours, one on February 4, 2020, and again on September 15, 2020. I can understand you wanting to go through and redepose her. I said, I'm going to be looking at the errata sheet. And I did that, Judge. I went back and I looked at the errata sheet personally. And we took the errata sheet down from 15 pages down to 5 pages. And it's a total of 5 pages of questions that I believe are objectionable. And I objected to many, many more questions than that, just objective form, which the rules provide for. But I didn't give speaking objections that go on. And he said, no, I can't agree to do it without closed captioning. And so my thought, Your Honor, is what I'd actually said to Alan, not 6, I've said 6 hours, but what I went on to say was, Alan, I'm really not going to tie you down as long as it's in one day. You want to start early, we stay early, we go a little later. I'm not going to put a time limit on you so long as you're asking questions that are going to be related to the errata sheet and not get off that and try to go back and rehash things that are already there. And let me just say, Your Honor, in front of you and in front of a jury, this witness is not going to be allowed by me. I'm not going to be foolish enough to say that she didn't understand something. If she's going to say that she didn't hear it and therefore couldn't understand it. But the woman has a severe hearing loss in her left ear. And I know there's my audiologist says one thing and one proffered by Alan says something somewhat different. But even then, Your Honor, I think that if you allow 6 hours, that ought to be it, unless there's something unusual. In other words, it'd have to be something extreme. I've known Mr. Lowenson a long time. And as soon as we say to him, you can go 6 hours, and then if something happens, you can come back for more, he'll be back for more regardless. He's going to be back for more regardless, Judge. I mean, I'm not trying to be critical of anybody, but if you leave that door open without saying, only in a very, something's going to have to be different.
Why don't we say absent good cause shown? I mean, that would
Absent
be.
good cause shown would be good, as long as we have something like that where there's an understanding that I'm not going to be in a deposition. These guys on this screen will tell you, they've been in depositions with me, and I'm neither obstreperous nor difficult. I don't give speaking objections. I follow the rules. I rarely instruct my witness not to answer, but I reserve the right to do so if they're asked things that I think would warrant such an instruction. But I'm very careful about how I do in a deposition, and respectful, because I know that deposition can and likely will be shown to you, other judges and their courts if they were there, or shown to juries, and I'm not that stupid. And so the point being is, I know how you have to conduct yourself, and I have no issue with giving them an additional 6 hours so long as she's got closed captioning. And for good cause shown, if they want to show you that for whatever reason they thought they need to go back and ask for more time, then we'll do that on a motion based on good cause shown, and I'll respond to it. We'll have a hearing if need be, but I'm hopeful we can avoid that. I'm hopeful we can avoid it.
That sounds fair to me, Mr. Lowenson.
That's what I propose to begin with. By definition, anytime you come before the court for more time, you've got to
Well,
show good cause.
I want to make it clear, it's absent good cause shown. It's not.
No,
just
I understand, but can I just point out one other thing to you? Why?
Well, I want to say one other thing, though, is that I do think Mr. Godwin is being kind of generous here in that he frequently, I mean, we've all been doing this a long time. I don't remember a whole lot of cases that I've seen where somebody's been allowed to depose someone for 6 hours over an errata sheet. I mean, I know that this is kind of a long errata sheet, but still, that was just the fact that he agreed to that, I thought was a show of good faith. I'd say a lot of attorneys would come in and say, look, you can impeach her on that at the time of trial, but you're not going to get to do a new deposition. So anyway, you might want to take the win, Mr. Lowenson, but if you want to say something else, you can.
No, I do, but there's just one other issue that the
Okay.
court needs to rule on. And that is when. We have said that we believe, so here was the original agreement. The original agreement was Mr. Epstein and I would ask our questions for up to 6 hours, or I'm sorry, Mr. Epstein and I would ask our question first, and Mr. Friedman would then follow up with his. We would be given a maximum of 12 hours, okay? Mr. Friedman obviously will in part judge his questions based on what's already transpired, because he should not repeat, and I believe will not repeat what's already been covered, and needs to know what he still needs to cover. We believe we should be able to finish Gail's deposition, Mr. Epstein and I, including the errata sheet, on the questions we were asking. So Mr. Friedman knows what her final answer is, and then he picks up with his questions the same way it would have been had she not given an errata sheet and changed her answers. Mr. Godwin said, no, we have to wait until after Mr. Friedman is finished before we can ask our questions about the errata sheet, and I don't think that's the proper order.
I'm confused. Friedman still has
6 hours.
questions left out of his original 6 hours.
Well, it was an original 12 for the three of us.
Okay, so
Okay.
out of the original, so you're wanting to know if you can use some of that time and then use the additional 6
No.
hours?
This is simply of which happens first, one of two things. Does Mr. Friedman have to ask his questions in his remaining 6 hours, not knowing what she's going to say when she is deposed about her changes in her errata sheet? Or do we get to finish?
Why is he even allowed to ask those additional? If he didn't use the time to begin with, why does he?
Oh,
still
no,
get
we
to use
adjourned
it?
for the day.
Oh, you adjourned for the day.
Yeah, we were
okay.
going to come back a later day. So here,
And why was there even an errata sheet done if the deposition? Oh, because it's a continuation of a deposition.
that's a good question. I've never seen that when the deposition hadn't been finished, but they did one. So in any event, the choices are, first, what we are proposing is we get to finish, Mr. Epstein and I, Gail, on the questions we were asking with the errata sheet resumption. And then when that's done, Mr. Friedman does his up to remaining 6 hours.
I don't really care, but logically, I think it makes more sense to finish the fresh deposition and then go to the, to the impeachment on the errata, but I don't really.
Well,
have a
I'm
strong
actually
opinion.
arguing the opposite, and there's a reason for arguing the opposite. And that is that Mr. Friedman should properly tailor what he's going to ask and not ask based on what Gail has already testified to. If we don't understand what Gail has already testified to fully, which we won't until we depose her about her now 2 errata sheets, then Mr. Friedman will not know what it is he still needs to cover and not. And so all I'm saying is it was agreed Mr. Epstein and I would finish, so we should be able to finish with the errata sheet. And then once she has pinned down, if she is pinned
Did
down,
you already start deposing her on the errata sheet? Can
No.
you say
No,
finish?
finished our questioning. of
You're
her,
questioning, but you've
which
not.
will now be on the errata sheet only.
I don't really have a strong opinion, but Mr. Godwin.
Let me voice it this way. I've not been asked that question, Judge, would I do it? But I have no issue with Alan and Robert being able to come back for their maximum of 6 hours and clear up any issues on the errata sheet, but up to 6 hours and no more time unless good cause shown. I have no issue with them doing that, and then Mr. Friedman coming in after they're through in a spirit of compromise and trying to show good faith and work through the thing. I don't have a problem with letting them go through another 6 hours or whatever time they need, but no more than 6 hours without you giving additional time after a motion's filed. And then Mr. Friedman can ask his questions after that. Mr. Friedman has told me that he's not going to need 6 hours, but if he does, he will. He's not waiting.
He's already used some of his time, right? Or no?
No, he's not used any of it, Your Honor.
Oh, so he has six.
He has
6.5 hours.
He has 6 hours, Your Honor, thereabouts, and whatever he needs. I've litigated enough with Larry over the years that if he needs longer, I'm going to give him what he needs within reason. I mean, we're not going to argue with each other over it. We know how you expect things to be done in your court, and we're going to do that. And so I have no problem with doing it. What I would ask you to consider is this, Judge. We do the deposition of Gail. Whenever I've come in recently and wanted depositions, you said, I don't want any more depositions or discovery till after we have the summary judgment heard and ruled upon on this res judicata. And so what I think Alan's probably going to want to do is take Gail's deposition before that is done, which seems highly unfair to me. You've already said we're going to have the motion filed. It's going to be on the law. It's going to be res judicata. And after that, if the case is there, you go forward to more depositions. If it's not, if part of it's carved up, then you may not go forward at all. If you do, with a lesser portion of it. So all I'm saying, Judge, is that I have no problem giving them the 6 hours for Robert and Alan to redepose her on the errata sheet, and then Larry come in after that. But let's resume that deposition. Let's set it again after we get the ruling that you talked about, and that is the ruling on the motion for summary judgment. And Seymour said,
what's kind of good for the goose is good for the gander, it seems like. But
Your Honor,
what I'm saying, Judge.
excuse me.
And so they've been asking me not to have any depositions before a ruling on their summary judgment, and you ruled that's the way it was going to be. I'm saying let's just have the rule go both ways. It applies to them as well.
Your Honor, I was not going to propose to resume our deposition before the summary judgment hearings anyway, so I don't think we have a debate there. Can I just get one clarification, or just make sure we don't need a clarification? I don't know if the court understands what has happened here. She had 172 changed answers in errata sheet number 1, which was timely, assuming she can do it after the portion of her deposition. And then 3 days ago, untimely, she submitted an amended errata sheet. Now, the amended errata sheet is significant, not in terms of the number, but it's significant because we have no idea now what her final testimony is. Let me give you one example, and there are countless. In her original deposition, at one point, she's asked a question, and her answer is, I don't recall. In her first amended errata sheet, she changes an I don't recall to December 20th, 2019. In her second amended her first amended errata sheet, now her third swearing, she omits the changed answer. So as we're sitting here now, we don't know if her answer is, I don't recall, or if it was the now omitted December 20, 2019.
I have to be honest. I've never heard of amending an errata sheet. I don't know what the effect of an amended errata sheet. If can you do that past the time? I don't know. Is there any case
Judge,
law?
I did it. I'm willing to withdraw it. I did that in order to show good faith that you got an errata sheet. And I know the effect of an errata sheet is to be able, they can show it in front of a jury or do whatever they want to do with it. But when they complained about the errata sheet being too lengthy, I then took, and which I didn't prepare, I took and looked at it myself, and I said, I'm gonna look at it personally. I looked at it and I said, okay, in order to try to compromise and pare this thing down, I want to pare it down to what I think we really need to do. We pared it down to 5 pages. If they want to, I'm saying to you and to them, I'm willing to withdraw that 5-page amended errata sheet, go with the original one, and they depose her on that. I'm not trying to play a game here. I did that in an effort to show, guys, if you've got an issue with it, that's the kind of the way I was trained, and that is you meet and confer, you talk about things. And I did it as a spirit of meet and confer, if you will. And that is to visit with guys that we can't do it in person. And that was to say, okay, rather than you argue about it, let me pare it down. If they don't want it that way, we'll leave it like it was. It was really just good faith, Your Honor.
Okay. I guess my thought is that if they're objecting to the amended errata sheet, you withdraw it. If they're not objecting, then you'll go forward with it and limit the amended would take the place of the original if everyone agrees.
Let's hear what they want to say, Judge. Alan, you want to withdraw it? You want to object to it, to the amended errata sheet?
Well, here's my question, Your Honor. I understand negotiation and compromise, and I'm all for that, but we're not talking about negotiating positions. We're talking about, it sounds like, negotiating sworn testimony. She is sworn to the second errata sheet, which omitted sworn answers from the first amended. If she wants to, in writing, swear that she is standing by her sworn first amended, that's fine. But otherwise, I've got a sworn second errata sheet that doesn't have what's in the first sworn errata sheet. I don't know how you settle and compromise people's sworn testimony.
I'm going to ask it again, Judge, because I can stand on either one of them. If I filed on Friday an amended errata sheet to try to parse down the number of issues to argue about, if they don't like that and they think I ought to be stuck with the first one, I'll withdraw the second one. Okay. I'll withdraw the one we did on Friday and we'll stand on the other.
Why don't we just do that? You guys, I think we understand what the issue is. It's not really teed up for today anyway. So if you guys confer and you decide you want him to withdraw I don't even know if there's what the effect of it, if it's late anyway, is there going to even be any legal effect to the second amended errata sheet, or the whatever it is, the second errata sheet. But I don't think that's really what we're fighting about today anyway. That's not, well, that could be an issue for the deposition. Let's get on to, so we ruled on everything for the deposition.
I'm happy to withdraw it or leave it as it is. If they tell me they want to withdraw it, I'm making a standing offer that I'll withdraw the one we filed on Friday and we will go with the original one. And if I don't hear from them, then I'll assume that we're fine. But in terms of the timing of the deposition, I understand it's not going to resume until after a ruling on a summary judgment. Is that right, Judge?
That's right.
Thank you.
That's right. Okay, so we have you guys still need an argument on the motion to seal?
Yes, Judge.
Okay, I've read all of that as well. Kind of an interesting issue. I think you guys both have some really good points on this. I do admit that I find it hard to understand why we would, if there's not an agreement, why we wouldn't, or how we could really seal this entire case. But I do think that the executive compensation should be sealed. That's kind of where I'm leaning, but anyway.
Judge, I think that what we could do, those mathematical formulas, the bonus formulas are the sensitive part. And I think that in my working with Mr. Godwin, I'm sure that we could come up with an agreement where that if we were talking about the bonus formulas, the bonus formulas would not be attached. The executive agreements would not be attached as exhibits to the pleadings. And you know, that would keep it out. Another sensitive subject, Judge, for us is the fact that the divorce decree requires that the company be sold, and that that MHT, which is now a new entity, but that an investment bank sell the company. Our feeling is that if you put that out into the public, the value of the company goes down to the detriment of both shareholders. And we would ask that any mention of the sale of the company also be sealed. But those are the two issues for us. If we could get an agreement from Mr. Godwin that the executive agreements would not be attached as pleadings, and that there be no mention of the sale of the company, I think we're there. And just so that you know, Judge, we've had this is the second time, well, this is the first time we're hearing it with you, but we had this hearing when this matter was in front of the 254th, after this lawsuit was transferred to the 254th. We heard this motion, and it was in front of Judge Turner, and Judge Turner agreed that it should be sealed, and that is his ruling sheet is our Exhibit H.
He never put it in an order, though, Your Honor.
Well,
Never
Don,
was put into an order.
I'm still talking.
I'm sorry, Seymour.
It is true that what happened was we had the hearing, the judge issued his ruling sheet. Both Mr. Godwin and I submitted our proposed orders. It sat on Judge Turner's desk for a while, and then the Court of Appeals granted Mr. Godwin's mandamus, and the matter came back to you. So Mr. Godwin is right. There is no actual order, but we did try this, and you do know how Judge Turner ruled. But again, if we could get an agreement that the bonus formula.
One thing that I'll say, and I don't have any problem. I think that's the sale, I think, is a closer call, but I do think the bonus formula definitely should be protected. But one thing you have to understand is that Judge Turner is a family court judge. I'm a civil court judge. And so a lot of the other things that may be going on in terms of the personal relationship between Gail and her husband are not as much of an issue in this court. And so that may be, did he seal the entire case? Is that what he did?
He just said that the motion was granted.
To seal the entire case?
All I'm saying, we asked for the entire case to be sealed.
Okay.
He said the motion was granted. Again, we sent him proposed orders, but Judge, let me just say right now, if you give us the bonus formulas and the sale of the company, I'm done.
Mr. Godwin?
May I respond, Judge? Well, we're not going to agree now or at any time to agree to seal any part of this case. This case has been pending for a very, very long time. In February of this year, Your Honor, in 2020, there was a lengthy injunction hearing, and some very horrific things were said about my client in open court and said by Cliff Fisher as well as others. And there was not one utterance or peep out of anybody. Why don't we shut the door? Why don't we seal it? Why don't we ask that nobody come in? And so the point being is, it was not convenient for them or a problem for them to have people hear about Gail. And this file in your court, and it is absolutely, where it's not sealed, is replete with accusations about my client that are just scurrilous and factually incorrect. We're not going to agree to seal any part of it. And Judge, there is no legal authority. I'll look at that later. I don't need to be interrupted, please. There is no legal authority out there that executive compensation should be sealed or that it's a trade secret. To the contrary, the legal authority in Texas is executive compensation is not a trade secret. There are executive compensation agreements, Your Honor, for Larry Teal and Ted Uzelak, two of the gentlemen that are also parties in the litigation. There's no mention of confidentiality in their agreements. The company didn't have any agreement regarding confidentiality with them, and there was none there. But Judge, before we go back and even argue, and I want to continue if I need to argue the merits of this motion, let me go back and point out to you, they filed a second amended motion last Wednesday, and it substantively changed their first amended. And even Mr. Robert Seymour says in his objection to my motion, which is really not a motion in and of itself, but it speaks to the sealing motion, he says that an amended pleading takes the place of the original pleading. Judge, the law is very clear. I didn't need to file anything. I could have come in here today and not said a word. The law says that when you're going to try to seal a file, we all know that the preference in Texas is for there to be open courts and open forums, and it very rarely are you going to close the courtroom. In family cases, they do it more often than not. In civil cases, very rarely. It's done in family cases, and I've seen it done over there because I've done a lot of that work over the years as well. I can tell you can see it happen there. Mr. Turner is a special master there in the family court. He's not in your court, and he never put into an order what it was that he reportedly said there, Judge. But in terms of the argument about, well, in the decree it says the company's going to be sold. That was a statement in the decree, Your Honor, that was made where there was no lien on the company, no tax liens, no note owed, and there's no legal authority whatsoever. It's already been briefed. It's already been briefed by both sides. There's no legal authority in Texas that says that a judge can order the company be sold to the highest bidder. It's just going to be sold and within a certain parameter or a period of time. And so we've appealed that, Your Honor. That's before the Dallas Court of Appeals. The same one that granted us the mandamus that sent back a large portion of the case to your court where it should have been in the beginning with regard to the breach of fiduciary duty claims and those that were not purely involving the divorce or the enforcement of the decree. Judge, they should not be allowed to even be having this hearing today under the law. Under the law, and if we're going to go this far and they're going to be told I got to argue it, I'm going to want to order on that so I can decide what I'm going to do with it. But I'm willing to right time argue the merits of this motion to seal. But that time is not
So
today.
let me just say this. So I agree with Mr. Godwin to this extent, which is I really don't think that this is, first off, I'm not going to seal this case in the entirety. I don't, and I understand, Mr. Roberts, your position on the executive compensation. I do think that's a trade secret, but I don't think a motion to seal is the correct procedure. It should be a motion for protection. So I would suggest you file a motion for protective order and on that, and we can, or request for confidentiality order or something like that. But a motion to seal is not, I don't think, the correct procedure to deal with this issue. The issue on the sale, maybe I'm a little bit confused. So was the company ordered to be sold by the family court?
Yes, Your Honor.
Yes.
In the
Yes, Your
decree
Honor.
we've appealed from.
And is that case sealed?
Yes,
Yes.
it is, Your Honor. And I tried the divorce for these parties, and that was the most salient issue in the trial was the sale of the business. It's an integral part of the family law matter, which is sealed in its entirety. And so.
Well, then I don't think it should be brought up in this case. If it's sealed in that case, it shouldn't be brought up in this case.
Well, Judge, I'm just unwilling to agree. We've appealed that. They have not filed anything in the appellate court asking that any part of the briefing be sealed. There's nothing there to my knowledge where they've asked for that. And so Judge, I'll just say to you again, that I don't mind arguing and debating an issue at the right time. They did not give 14 days notice for this hearing today. They did not properly post it with the clerk here as they're required to do by the law. And they didn't do that under 76A, and they didn't give 14 days notice. And now they're saying in their pleading, well, if we fail on the 14 days, maybe we can go back and hear the other one. Well, the fact of the matter is, when you file an amended pleading.
Oh, they didn't give 14 days notice on the amended posting.
On the second amended, they filed Wednesday, there's not 14-day notice. I don't think this matter's ripe to be heard today. And when it is ripe to be heard, I'll be ready to argue it, but I want to be clear with the court and upfront with everybody. I'm not going to agree to seal any part of this case because I don't believe that the law requires it, or it can be supported if necessary to be looked at by another court. I'm not going to agree to it. It's ridiculous to do it.
May I respond?
We shouldn't be arguing with the judge today. I have a right to say where they have a procedural requirement to post and give 14 days notice. They have to do that. And if they don't do it, they do it right. And then we come back and argue it right and correctly at the right time. That's not today, Judge.
Mr. Roberts.
All right, Judge. Mr. Godwin has made a number of points, and I'm going to go over all of them with all due respect. The first point he made was that at the February 10th hearing on the emergency injunctive relief application that the company filed, that a number of allegedly scurrilous things was said about Gail, and that nobody tried to seal the court. I would point out, Judge, that conspicuous by its absence in Mr. Godwin's argument was that he didn't try to clear the court either. We all know Mr. Godwin, he's not shy. And at any time during this hearing, he could have stood up and said, Judge, bad things are being said about my client. We need to clear the court. He never did that. The hearing took place all day. It was from about 10 to 6, okay? So he had every opportunity to clear the court or to at least ask for that relief. Also, conspicuous by its absence was any testimony from Gail. Gail was in the courtroom. Don Godwin argued that Cliff Fisher said terrible things about Gail Fisher, but Gail Fisher was in the courtroom and Mr. Godwin never called her. So what Mr. Godwin is arguing is that because he didn't protect his client's best interests by clearing the courtroom, we have to suffer because we're trying to protect our client's best interests. That's just clearly wrong. Now, the next argument he makes is that the company has not really tried to protect its trade secrets. And I want to point out to you, Judge, that attached to our exhibit as exhibits for this hearing today, we have Mr. Uselak's employment agreement and Mr. Teal's employment agreement, and both of them have a confidentiality provision. And the Teal provision also includes something on trade secrets as well as confidentiality. And trade secrets, Judge, is defined as all ideas, not just a limited type of idea. It's not just some kind of a scientific patentable formula. It can be any idea that gives you a commercial advantage. Not only does the company require its employees, other than Gail, to have these agreements, but there's also a company policy, a manual. And we've attached that as an exhibit that talks about confidentiality with such a broad definition as to include compensation agreements. And if you look on page, I believe it's 14 of my policy manual, which is an exhibit, to my pleadings today, you will see, that's our Exhibit E, you will see that failure to comply with the confidentiality provision is grounds for termination, which means that if Gail doesn't keep the bonus agreements secret, she could be fired. She's doing this to herself. It's a spiteful, cut off your nose to spite your face litigation strategy, which has no business being in this court. Now, let me talk about the appeal for 1 second. Mr. Godwin emphasizes that he has appealed the issue of the sale of the company. Again, conspicuous by its absence is Mr. Godwin telling the court that the appeal did not include a supersedious bond. You don't include a supersedious bond, then the prior order can be enforced. Not only was there no supersedious bond filed, I don't believe there was a hearing to determine the amount of the bond that might be necessary. There was no even attempt to even look at that issue. Okay, let me now talk about the amendment. On Wednesday of last week, we did file an amendment, and what we did was, we did not add anything. I took facts out. Judge, I don't have COVID, if you're wearing that mask for me.
It's okay. Somebody just came in.
Okay. What we did is if you take a look at my response to the motion to seal, we removed a ground for relief. We removed one of the legal arguments. What we did add was some case law on the Texas Uniform Trade Secret Act. However, Judge, all that the Rule 76A3 requires is a short mention of what the claims are in the case. It doesn't require us to file the pleading. Nothing in any new public notice would change. I'm just going to take the old public notice and refile it. There is nothing new there. And we can have a hearing today on the unamended motion for the simple reason that it's still on the docket. Okay, it doesn't vanish into thin air. It doesn't become a nullity. It's still there. And so we complied with the notice. We can still have the hearing on the unamended pleading. But I want to emphasize again before I stop.
Okay, I got it.
Okay.
Okay, so let me just kind of summarize here. I'm denying the 76A motion. I would strongly encourage you to file that as a motion for protection. And let me explain one reason why I'm denying it, not the only reason, but one reason I am denying it, is that it is extremely difficult for the clerks, if not impossible, to seal part of a document. So you're asking basically for them to go back through and try to seal portions of documents that have been filed in the past. That's very, very difficult to do. That's not the only reason, but I think it'd be a much more effective way and appropriate way to do this is to file this as a motion for protection. Secondly, I raise a great deal of concern that if this has happened, and I'm not exactly clear if it has happened, but if there is something that was sealed in Judge Wysocki's court and has been filed in this court unsealed, I am very concerned about that, if that's what's occurred. I'm not sure if it has, but we're obviously discussing on YouTube and on the record about this sealed order of sale or whatever it was exactly. And that concerns me. Just because it was sealed by another court, it doesn't mean you can go into some other court and then make what was once sealed unsealed. I don't think you can do that. I think that addresses all of the issues. I feel very strongly the executive compensation should be protected, not in a 76A motion. Anything else we need to talk about?
Judge, would you like for me to grant, to draft the order denying the motion?
Yeah, somebody needs to for the first order involving the deposition, Mr. Lowenson, why don't you go ahead and draft that order and share it with Mr. Godwin? And then Mr. Roberts, why don't you draft the order involving the motion to seal? And feel free to file a motion for protection on the issue of the compensation. Mr. Godwin, it's your call if you want to fight that, but I just want to be honest with you. I feel very strongly that, and maybe the Court of Appeals will differ with me, but I feel very strongly that executive compensation should be protected, especially in this type of situation. So
whenever you're ready, Judge, I'd like to speak just briefly.
Briefly.
Okay. Obviously, I'm only going to resist and fight, as you suggest, what needs to be fought and where I think the law requires it. And I'm not going to fight something just for the sake of fighting it. But I will. I've looked at the issue of executive compensation in this context, and I'm not going to be able to agree with them on that. And we just wait to see what their motion says, and then we will argue it, and we'll bring the proper law before you at that time. It was not argued today because it couldn't be argued legally today based on this matter not being ready for a hearing because they didn't properly post and give 14 days notice. We've got the law here, and we'll address that when I see Seymour's motion. We'll address it at that point. But so I'm clear, without any added language, the 76A motion is denied today. Is that right?
It is denied.
Okay. And Alan's motion, we've resolved it by agreeing to 6 more hours. And then if he decides that he needs to come back for additional time for good cause shown, he can do that, but not otherwise.
You're correct.
Thank you, Judge.
All right. You guys have a good day.
Thank you.